You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The USA Freedom Act, passed in 2015, was crafted as a legislative response to growing public concern about the scale of bulk surveillance revealed in 2013. Its statutory purpose was straightforward but transformative: to end indiscriminate collection programs and replace them with targeted mechanisms built on narrower, more discriminating criteria. Under earlier frameworks, particularly Section 215 of the USA PATRIOT Act, agencies had compelled providers to deliver entire datasets of telephony metadata for government storage and later analysis. The Freedom Act sought to close this chapter by prohibiting bulk acquisition across federal authorities and requiring all compelled production to be tied to a specific selection term. For learners, this shift represents the movement from dragnet-style surveillance to a more proportional model. The reform aimed not only to restore trust, but also to demonstrate that intelligence collection could proceed effectively within boundaries set by law. At the heart of the reform was the specific selection term requirement, often abbreviated as SST. This provision required agencies to define precise identifiers such as phone numbers, account credentials, or device identifiers when submitting requests to providers or courts. By mandating specificity, the law directly barred expansive orders that could capture entire provider databases or broad geographic regions. For learners, this concept illustrates how abstract principles like minimization are translated into enforceable statutory requirements. Specific selection terms create natural technical limits. The narrower the term, the smaller the scope of the collection. This ensures that surveillance activities are directed at particular individuals or entities relevant to an investigation, reducing the collateral intrusion on innocent third parties. It transforms surveillance from a model of collect first, analyze later, into one of disciplined targeting where necessity and relevance drive each collection decision. The Act also dismantled the controversial bulk telephony program by shifting responsibility for call detail record storage back to private providers. Instead of the government stockpiling vast amounts of metadata, companies retained records as part of their ordinary business operations. Investigators could then request targeted sets of data tied to approved selectors, but they had to go through court-approved processes to do so. This change marked a fundamental restructuring of how metadata surveillance functioned. For learners, it is an important case study in how structural reforms can achieve both operational and privacy goals. By leaving retention with providers, the law minimized risks of centralized government repositories while still enabling investigators to trace connections when legally justified. The Freedom Act's model showed that oversight and restraint could coexist with investigatory capacity in practice. To further constrain scope, the law imposed a two-hop query limitation on call detail record searches. This meant that once an approved selector was used, investigators could see the target's direct contacts and then one additional level of contacts outward. Beyond that, additional court authorization was required. For learners, this illustrates how legislatures use layered safeguards to balance investigative breadth with privacy. Two hops were considered sufficient to map relevant networks without allowing endless expansion into unrelated communities. This limitation demonstrates how statutory rules can encode proportionality. The government can explore connections, but the circle of inquiry cannot expand indefinitely. For students of privacy law, the two-hop rule is a prime example of how law attempts to capture a nuanced compromise between operational necessity and protecting broader populations from collateral data collection. The Freedom Act also enhanced the oversight role of the Foreign Intelligence Surveillance Court, or FISC, which reviews applications for surveillance orders. The law empowered the court to engage with a broader range of perspectives by appointing special amici curiae, independent legal experts who could provide analysis on novel or significant issues. This reform was critical because the FISC traditionally operated ex parte, hearing only government arguments. For learners, this innovation demonstrates how procedural design can strengthen accountability even within classified systems. Introducing independent voices helped ensure that requests were not rubber-stamped but examined with adversarial rigor. This change underscored a broader principle. Secrecy in national security contexts must be counterbalanced with meaningful oversight, and courts require tools to test arguments critically, rather than relying solely on agency representations. Minimization and querying procedures received renewed emphasis under the Act, requiring agencies to establish strict internal guidelines for retaining, using, and disseminating acquired data. These procedures enforced the principle that data must not only be collected lawfully, but also handled responsibly throughout its life cycle. Retention limits ensured that records were deleted once they were no longer relevant, while querying rules documented and approved searches against collected datasets. For learners, this demonstrates how privacy protections extend beyond the moment of acquisition. Lifecycle governance recognizes that data's risk profile increases with time, and even lawfully obtained records can become problematic if they are stored indefinitely or misused. Embedding minimization into statute reinforced that intelligence powers must remain tethered to necessity at every stage of the process. Pen register and trap and trace authorities were modernized by the Freedom Act to reflect evolving communication technologies. Historically tied to telephony, these tools track dialing, routing, and signaling information but not content. The reform ensured that such collection adhered to the same targeting principles, requiring specificity and relevance rather than broad authorization. For learners, this adjustment highlights the continuity of privacy debates across different surveillance tools. Even when the data seems limited to metadata, aggregation and analysis can reveal intimate patterns about behavior, location, and association. By extending reforms to these authorities, Congress signaled that precision and minimization are not optional. They must permeate all facets of surveillance, regardless of whether the data at stake involves call logs, internet headers, or other forms of non-content signaling information. National security letters also came under reform through the Freedom Act. The statute required that non-disclosure or gag orders attached to NSLs be reviewed periodically, preventing indefinite secrecy without judicial reevaluation. Providers gained clearer pathways to challenge gag orders in court, enhancing transparency and due process. For learners, this reflects the recognition that secrecy can be necessary but should not be perpetual. The requirement for review introduces the principle of sunset into non-disclosure obligations. Unless secrecy remains justified, transparency should gradually return. This reform balanced investigative integrity with free speech and accountability, illustrating how surveillance law evolves to address not only technical scope, but also the civil liberties dimensions of communication between providers and their users. Another transparency measure required the declassification or summary publication of significant FISC opinions. These opinions, once secret, contained important interpretations of surveillance law that shaped practice in profound ways. By making them available, the Act increased public understanding of how laws were being applied in practice. For learners, this reform illustrates how transparency can be layered, with classified details withheld but broader reasoning shared to facilitate democratic debate. It demonstrates that oversight is not only about compliance mechanisms inside the government, but also about public legitimacy, which requires visibility into how powerful tools are interpreted by courts entrusted with protecting rights. Declassification of opinions helped demystify FISC's role and brought legal reasoning into the democratic arena. Annual transparency reports by government agencies became another statutory requirement, disclosing metrics about the number of orders issued, selectors used, and compliance outcomes. Private providers were also permitted to publish their own reports using banded ranges, offering customers greater visibility into how many requests they received. For learners, these reporting obligations illustrate how information disclosure fosters accountability even in classified contexts. While the data is often high-level, it provides benchmarks against which oversight bodies and the public can measure proportionality. Transparency reports shift the narrative from secrecy-driven speculation to structured, periodic disclosure, demonstrating that lawful surveillance can be monitored quantitatively even if operational details remain hidden. The Act also clarified boundaries between content and non-content records for compelled production, By reinforcing that content remains subject to higher thresholds such as warrants, the Freedom Act reaffirmed long-standing privacy distinctions. For learners, this clarity is essential because ambiguity about content versus metadata had enabled expansive interpretations in the past. By anchoring categories explicitly, the law limited room for reinterpretation and provided providers with greater certainty about compliance. This reflects the governance principle that precision in statutory language is a privacy safeguard in itself, as vague laws invite expansive reading while clear definitions enforce restraint. Technical feasibility provisions were added to ensure that providers were not compelled to perform impossible or overly burdensome tasks. If a request was not technically feasible or would create disproportionate costs, providers could object or seek modification. For learners, this reflects a recognition that compliance frameworks must be realistic. Mandates that exceed technical capacity not only risk unfairness but can also undermine trust in surveillance regimes. Feasibility clauses show how law acknowledges operational realities, aligning surveillance demands with the infrastructure capabilities of private companies that act as intermediaries in compliance. Finally, sunset provisions embedded in the Freedom Act required Congress to revisit these authorities periodically. Provisions would expire unless reauthorized, forcing lawmakers to deliberate about their continued necessity. For learners, sunset clauses embody the principle of recalibration. Extraordinary powers granted during times of urgency must be reassessed to ensure they remain justified. By mandating debate and reevaluation, sunset provisions provide a democratic safeguard against unchecked permanence, ensuring that reforms continue to evolve with both the threat environment and societal expectations about privacy. This recurring cycle keeps surveillance law dynamic and prevents extraordinary measures from quietly becoming permanent features of ordinary governance. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The USA Freedom Act not only reshaped how data could be collected, but also placed heavy emphasis on oversight and auditing requirements. Inspectors general within relevant agencies were tasked with conducting periodic reviews of compliance with targeting and minimization procedures, and their findings had to be reported to Congress. This created a multi-layered system of accountability, where not only the Foreign Intelligence Surveillance Court, but also internal and legislative bodies could examine performance. For learners, these audit provisions highlight the idea that privacy protection is not guaranteed by law alone, but by ongoing scrutiny. Audits force agencies to demonstrate that their practices match statutory promises and provide a corrective path when errors or overreach occur. By embedding compliance reviews into the structure of surveillance law, the Act recognized that effective privacy protection requires continuous oversight, not one-time legal standards. Another critical reform introduced by the USA Freedom Act was the requirement for purge triggers and retention limits. Data collected under targeted orders could not be stored indefinitely, and agencies had to establish documented processes for destroying information once it was no longer relevant. For learners, retention and purge requirements emphasize the life cycle nature of privacy. Collection is only the first step. What happens afterward determines long-term impact. By requiring purge triggers, the Act acknowledged that holding data carries risks, including mission creep and unauthorized use. Documenting these processes ensures accountability and gives oversight bodies tangible metrics to evaluate compliance. This reform shifted intelligence collection away from hoarding information toward a more disciplined model where data is actively managed, reduced, and eventually erased in accordance with statutory obligations. Query logging and approval trails became central safeguards under the Act. Every query of collected datasets had to be documented, and access was limited to trained, authorized users. Approval mechanisms created a paper trail that could later be reviewed by auditors, the Department of Justice, or congressional oversight committees. For learners, query logging demonstrates how accountability can be operationalized. While laws can prohibit misuse, enforcement requires visibility into actual practice. Logs act as both deterrents because analysts know their actions will be reviewed, and as evidence when oversight bodies investigate compliance. The emphasis on training ensures that those handling sensitive data understand both the legal standards and the ethical stakes. Together, these requirements transformed querying from a largely internal matter into a process bound by external visibility and procedural discipline. Use limitations were another pillar of reform. The USA Freedom Act restricted the purposes for which collected data could be used, confining it to national security and foreign intelligence contexts. Dissemination for unrelated purposes, such as domestic criminal investigations, was prohibited unless separate legal authorities applied. For learners, this provision reflects the privacy principle of purpose limitation. Data collected for one reason cannot automatically be repurposed for another, especially when the new use may intrude more deeply into individual rights. By codifying use restrictions, the Act aimed to prevent surveillance data from becoming a general-purpose investigative resource. It reinforced the notion that national security powers must remain exceptional and bounded, rather than spilling over into ordinary law enforcement without distinct legal checks. The Act also addressed criminal notice obligations, requiring that when information derived from USA Freedom Act processes is used in criminal cases, defendants must be notified. This enables judicial review and provides individuals with the opportunity to challenge the lawfulness of surveillance. For learners, this is a critical procedural safeguard. Transparency in criminal contexts ensures that secrecy in intelligence collection does not undermine fairness in prosecution. Litigation pathways also serve as checks, as courts reviewing these cases help clarify constitutional boundaries and refine how surveillance authorities can be applied. Notice obligations thus create a feedback loop. Intelligence feeds criminal cases, which in turn trigger judicial scrutiny, helping to align practice with constitutional protections. The USA Freedom Act also clarified its relationship with other statutes, particularly the Electronic Communications Privacy Act and the Stored Communications Act. These older laws govern access to stored data and metadata in criminal and civil contexts, and the Freedom Act reforms had to integrate without disrupting established frameworks. For learners, this interplay illustrates the patchwork nature of U.S. surveillance law. Rarely does one statute operate in isolation. Instead, overlapping regimes must be harmonized. Understanding how these laws interact shows why compliance requires both legal expertise and operational sophistication. Providers must parse which statute applies to a given request and ensure that obligations are met without overproducing data. This complexity underscores why governance structures must be robust enough to handle nuance. For enterprises, the transition from bulk models to narrowly tailored demands required significant changes in compliance posture. Bulk orders had required providers to deliver large volumes of information regularly, while targeted demands required systems capable of extracting data tied to specific selectors. Providers had to build new tools, retrain staff, and design workflows to accommodate narrower but more frequent requests. For learners, this operational shift highlights how surveillance reforms ripple into private sector governance. Compliance is not abstract, it is technical and procedural. By requiring targeted access, the law forced providers to become more precise in data handling, embedding minimization into both legal and technical design. This transition underscores how privacy reforms shape not only government practice but also corporate infrastructure. Liability protections were maintained for providers complying in good faith with court-approved requests. The Freedom Act reaffirmed that companies cooperating under lawful orders would not face civil liability from customers upset by disclosures. For learners, this reflects the balance between trust and obligation. Without immunity, providers might resist cooperation, undermining investigations. With immunity, cooperation is encouraged, but companies must still safeguard against overcompliance. These protections illustrate how law attempts to balance competing incentives, encouraging providers to honor legal obligations while ensuring that safeguards, such as specificity and minimization, prevent abuses. Liability protection thus enables cooperation while keeping the guardrails intact through statutory constraints. Non-disclosure orders were also refined under the Freedom Act. Courts were required to review the duration and necessity of gag orders, and providers were given clearer rights to challenge them. This reform addressed the problem of perpetual secrecy that had plagued earlier regimes, where companies were gagged indefinitely from even acknowledging receipt of legal process. For learners, this demonstrates how surveillance law evolves toward more measured secrecy. Gag orders remain necessary in active investigations, but unchecked secrecy erodes public trust. By requiring judicial review and renewal, the Act created a system where secrecy must be justified over time rather than assumed as permanent. This balance ensures that privacy rights regain force once investigative needs diminish. Coordination with state, local, and tribal authorities was also recognized. National security investigations often overlap with local enforcement, and the Freedom Act ensured that data sharing and parallel investigations were conducted under consistent legal frameworks. For learners, this coordination illustrates the importance of harmonization in privacy governance. Fragmentation across jurisdictions can create risks of overdisclosure or underdisclosure, while consistent standards improve both efficiency and accountability. This provision reflects the broader theme that surveillance governance must function not only vertically between government and providers but also horizontally across jurisdictions, ensuring coherence in a complex investigative ecosystem. Cross-border considerations presented another challenge. U.S. providers with international footprints faced potential conflicts between Freedom Act obligations and foreign privacy regimes, such as the European Union's General Data Protection Regulation. Comity principles and diplomatic frameworks became essential to reconcile these conflicts. For learners, this highlights how surveillance law is global in practice, even if national in design. Providers must navigate overlapping obligations, balancing domestic orders with international commitments. This complexity underscores the need for harmonized frameworks that respect both national security interests and global privacy standards. It also illustrates the growing role of international negotiations in shaping how surveillance authorities are applied in a borderless digital environment. Vendors and cloud providers also had to adapt to targeted order execution at scale. The Freedom Act required providers to implement processes that could handle frequent, narrow demands, often across multi-tenant cloud architectures. This introduced technical challenges, as providers had to segregate data effectively, maintain auditability, and prevent inadvertent overdisclosure. For learners, this demonstrates how surveillance law affects not only legal departments, but also technical architecture. Providers became responsible for engineering systems that could deliver compliance while protecting privacy. This shift illustrates the convergence of legal frameworks and technical implementation, where governance is operationalized through design choices in modern cloud and vendor ecosystems. Metrics became central to evaluating the impact of the Freedom Act. Agencies tracked reductions in overcollection, improvements in minimization compliance, and enhanced transparency reporting. Providers published banded statistics on requests, while oversight bodies reported on compliance incidents and remedial steps. For learners, these metrics highlight how privacy reforms are measured not just in statutory text but in operational outcomes. Numbers provide visibility into whether reforms achieve their goals, reinforcing the principle that accountability requires quantifiable evidence. Metrics transform oversight from abstract assurance into demonstrable performance, enabling continuous improvement in surveillance governance. Finally, governance updates were necessary across agencies and providers to reflect the Freedom Act's new standards. Policies had to be rewritten, staff retrained, and transparency statements updated to align with statutory reforms. For learners, this illustrates how surveillance law reform is not a one-time event, but an ongoing process of institutional adaptation. Governance updates ensure that reforms are embedded into daily practice, not just codified on paper. Training and transparency reinforce the cultural shift from bulk collection to targeted access, making the Freedom Act not only a statutory milestone but also a driver of operational change. This demonstrates the principle that privacy protection ultimately depends on governance discipline, ensuring that reforms are lived realities, not theoretical aspirations. In conclusion, the USA Freedom Act transformed U.S. surveillance law by banning bulk collection and embedding targeted, auditable, and transparent mechanisms. For learners, the synthesis is clear. Reforms like specific selection terms, enhanced oversight, retention limits, and transparency measures work together to recalibrate the balance between national security needs and privacy protections. The Act's legacy lies in its demonstration that surveillance powers can be both effective and bounded, sustained by governance frameworks that ensure accountability, proportionality, and trust in a democratic society. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.